that involves a baby that, after just getting out of the NICU, ended up back in the hospital and almost died. Hi, I'm Roy Jacobs. I'm an attorney with Cape Fear Family Law, and I'm here to talk to you today about a recent case coming out of the North Carolina Court of Appeals that involves a baby that, after just getting out of the NICU, ended up back in the hospital and almost died. So this baby that the Court of Appeals called Nan was born premature in January of 2023, spent months in the NICU, but just a few days after getting discharged in April, ended up back in the hospital with a series of incredibly severe injuries that almost caused the baby to die. DSS got involved and stayed involved the entire time. Accidents are a fact of life, but the problem with this case in particular is that, given the severity of these injuries, neither parent, who were the only people determined to have been caring for the child at the time, could explain how these incredibly severe injuries actually happened. In most cases after an adjudication, the disposition requires that DSS has to make reasonable efforts towards reunifying the child with the parents. This case is interesting because at the initial disposition hearing, the Department of Social Services was relieved of its obligation to provide reunification efforts, and reunification efforts were ceased. The adjudication is a hearing to determine whether or not the facts alleged by DSS in their petition are true. They filed the petition in this case because the severity of the unexplained injuries of the child, DSS felt warranted them taking custody of the child. 3 skull fractures, brain and spine bleeding, retinal hemorrhages, in addition to the child needing to be resuscitated upon arriving at the hospital. This child was only outside of the hospital and in the parents' care for just a few days, but by the time the child arrived back at the hospital, the child had arrived back with retinal hemorrhaging, brain and spine bleeding, a fractured skull, among a litany of other injuries that there were no explanations the parents had. The father couldn't provide an explanation, and the mother said that she was at work when it happened. How did the adjudication go through if nobody to this day even knows what exactly happened? Well, neither parent ended up presenting any evidence at this hearing, and their attorneys even declined to cross-examine the social workers that testified at the adjudication. After an adjudication, the court moves into a dispositional hearing where it's trying to determine what the plan needs to be long-term for the child, and specifically a plan that suits the child's best interest. And usually, parents are afforded an opportunity to pursue reunification and have the child reunified with them. What is unusual about this case is that at this initial disposition hearing, the reunification efforts were ceased before the parents even had an opportunity to work any sort of case plan. If a court's going to do that at the first disposition, the court typically has to find certain aggravating factors, and those aggravating factors have to be very bad for a court to take a drastic step like this. Those aggravating factors include sexual abuse, chronic physical or emotional abuse, torture, abandonment, or exposure to controlled substances and alcohol, or other acts that the court determines meet the criteria for an aggravating factor that warrants ceasing reunification efforts with the parent. So given the injuries sustained by this child, you would think that the aggravating factors were present. What the Court of Appeals actually found was that the findings of fact by the district court actually did not support the ceasing of reunification efforts. Specifically, no matter how bad these injuries were, the court found that because of the short period of time that the child was actually in the parents' care outside the hospital, it didn't meet the definition of something that was happening on a chronic or repetitive basis. Now, you might be thinking that that's a good win for the parents in this case, who are going to be able to have a chance to reunify, but the Court of Appeals opinion indicates that is not likely to be the case. So the Court of Appeals opinion actually found that there was likely sufficient evidence in the record to support ceasing reunification efforts on other grounds than the chronic injury. Another ground the parents appealed on was that their attorneys did not put up much of a defense at the underlying adjudication hearing. The Court of Appeals didn't find any merit in that argument, particularly noting that the parents had pending felony charges related to the same incidents involved in this case, and that very likely could have been a strategy that counsel came up with to look out for their clients while still having to deal with this adjudication as best as they can. And while the parents' attorneys did not cross-examine witnesses or make any arguments at the adjudication, the court noted that at the disposition hearing that happened afterwards, counsel made numerous arguments and advocated on behalf of their clients to avoid reunification efforts getting ceased in the first place. So the court looked at this and determined that the attorneys probably had a sound reasoning for how they conducted this hearing and did not find that the assistance of their counsel was ineffective just because counsel didn't do anything in particular at one of these hearings. So the craziest and probably the most unfortunate thing to me when I look at this case is that because the mother seemingly, while she might not have had an explanation for how the injuries actually happened, she almost appeared to have had a defense as to why she might not have been responsible for them. But unfortunately, with the circumstances in it, not in the case, not only did she not have an opportunity to present that fact to the court, it's almost certain that now her rights are going to get terminated. And I don't think they should be. Well, maybe the dads ought to be. Or at least that she get an opportunity to try and reunify with this child. Well, I hope you never have an issue with DSS, but if you had, tell us about it in the comments and like and subscribe.